Okay, well, good evening, ladies and gentlemen. First of all, can you hear me? Okay, good. I think the microphone's working then. Welcome to the St. Stephen's Club for tonight's evening seminar. I'm Tom Clougherty. I'm the Executive Director of the Adam Smith Institute, and basically I'm chairing tonight's proceedings. I'm afraid I have to start with a slightly unfortunate announcement, which is that, as you've perhaps noticed, Graham Brady can't be with us tonight. Unfortunately, it's a family illness, so not his fault at all, but he sends his apologies, and if it's any consolation, we'll try and get him along to an event early next year. Now, basically, tonight's format, we're going to start by hearing from each of our panel members, about 10 minutes each, and then after that, we're going to open the floor to questions and discussion, probably do that for about half an hour more, and then if any of you want to stay afterwards to continue the conversation, there will be wine immediately after the speaking tonight. There might still be some canapes left, although I'm not entirely sure about that. Now, before we kick off, I'm going to briefly introduce each of our speakers, and I'm going to do it in reverse order. So, speaking third this evening, we have Geoff Cook, the Chief Executive of Jersey Finance since January 2007. Geoff's job is to promote the finance industry of Jersey, so obviously he's got a clear interest in Jersey maintaining its competitive tax system. Before joining Jersey Finance, Geoff was head of wealth management at HSBC. I would ask him for some tips, but unfortunately I've got no wealth to manage. Speaking second tonight, we have Richard Teather. Richard is a renowned European tax expert, a senior lecturer in tax law at Bournemouth University, and the editor of Finance Confidential. He's also a senior fellow of the Adam Smith Institute and the author of The Benefits of Tax Competition, which was published by the Institute of Economic Affairs. But first up tonight, and with my immense gratitude for stepping into Graham Brady's large shoes at the last moment, we have Richard Hay. Richard is an international tax principal at Stikeman, Elliott, and he's head of the London Private Capital Group, which advises banks and private clients on tax and regulatory issues. Now, our topic tonight, as you are aware, is tax competition, economic freedom, and national sovereignty. Richard, over to you.
Well, thanks very much, and it's certainly a great pleasure to be here tonight. It's a very exciting period in discussions over tax competition because we see a major development having occurred over the last month in this area, very striking. On October 13th, the Financial Secretary to the UK Treasury instructed the UK Crown dependencies that they must abandon tax systems adopted by them at the UK government request to address EU concerns over the EU's Code of Business Conduct. At the same time, the UK requested that the Crown dependencies condition any review of their fiscal policy on a presumption of a minimum corporate tax rate of 10%. I've been a tax professional for 30 years, a tax academic, tax practitioner for over 20 years in London, following this debate reasonably closely, and for the first time I am aware of in fiscal history, a large jurisdiction has demanded that small jurisdictions surrender sovereignty over their fiscal affairs so that a large trading bloc is relieved from the consequences of tax competition. So this is a critical inflection point in the global debate over tax competition. If the Crown dependencies exceed the UK demands, their tax-neutral platform may be damaged, with adverse consequences for the UK economy. The symbiotic relationship between the United Kingdom and the Crown dependencies and the rest of the British overseas territories that drives the prosperity in the City of London will be adversely affected. It's UK interests that are at stake here, as well as those of the Crown dependencies and overseas territories that support the City of London. This development is very surprising for several reasons. First, it is a deeply embedded element of international policy, frequently articulated by supranational bodies, including the OECD, that jurisdictions have the freedom to set their own tax systems and rates. There's a very good reason for this policy, and that is the sovereign members of these supranational bodies insist on this. The United Kingdom does not want the EU telling it what to do in its tax policy, and it doesn't want the OECD doing that either. There are a couple of recent limits on this that have come up over the last 10 years. One is tax information exchange. In 1998, the OECD articulated a demand on the small financial centers that they assist the large ones with tax enforcement by provision of information. Interestingly enough, this flew in the face of a long-established principle of international law established in this country by, or at least reiterated in this country in mid-50s in a judgment, Government of India and Taylor is the standard pronouncement on the subject. No jurisdiction has the obligation, unilateral obligation to another to assist with enforcement of taxes. Now, the OECD sought to overturn this principle without debate in 1998. I think the offshore centers saw in short order that if they wanted access to UK and other major centers, banking and securities markets, that they needed to accede to that. Now, I don't really regard this as an attack on tax competition. It's a peripheral element. It doesn't go to the core of prerogatives over design of a tax system. The other limit, of course, is the EU Code of Conduct, which is, has its main policy thrust a challenge to ring fencing. Now, ring fencing is, as many will know, offering a better deal to foreigners than the country makes available to its own residents. And it was a request to the Crown dependencies by the UK government that they adhere to the Code of Conduct in 2003 that led to the introduction of the tax systems in the CDs that are now condemned by the United Kingdom and the EU. And of course, by long-standing convention, although not sovereign entities themselves, the UK Crown dependencies and overseas territories enjoy sovereignty over their domestic fiscal affairs. Cayman challenged the EU in 2003 over the Savings Tax Directive and said Europe has no right to direct our internal fiscal affairs, and the ECJ agreed. So the legal position is quite clear, established by supranational bodies, by long-standing convention, by numerous court judgments, that no jurisdiction is obliged to adopt minimum tax rates or other impositions on their freedom to design their tax system at the behest of another. And this principle is now at stake. The UK government behavior is deeply discourteous in the sense that these tax systems were introduced at the request of the UK government and accepted by the EU throughout their adoption by the Isle of Man and the Channel Islands. Now, the UK, interestingly enough, has accompanied this demand that they change their tax systems with an instruction that the reviews, as I mentioned, are conditioned on a 10% tax rate. Now, why have they done this? This is an anti-tax competition measure. The United Kingdom has robustly rejected for a number of years EU efforts to dictate tax policy, for example, through the common consolidated corporate tax base. That's a harmonization of tax base. The EU has not been a particularly enthusiastic participant in that. It has never been part of the CCCTB that jurisdictions could be obliged to conform tax rates to EU policy. So we see here the United Kingdom demanding behavior of the jurisdictions which surround it, that they would not be willing to, or giving them directions they would not be willing to accept themselves from the EU. It's extraordinary.